Good morning and welcome to the Public Service Commission of South Carolina. It is Monday, June the 12th at 10:01 a.m. and we are here today in a hearing in docket number 2022-351-E. Let's take a roll call of commissioners. Present in the hearing room, we have Commissioner Justin Williams, Commissioner Thomas, Commissioner Carol Lee Williams, Commissioner Caston, and Chair Belser. With us virtually, we have Commissioner Irvin and Vice Chair Powers. I'm going to recognize our staff counsel, Ms. Clausen, to read the docket.
Thank you, Madam Commissioner. We're here today, June 12th, 2023, on docket number 2022-351-E, which is the application of the South Carolina Public Service Authority for approval of competitive procurement program pursuant to South Carolina Code Annotated Section 58-31-227. Madam Chair, the docket's in order.
Thank you, Ms. Clausen. Let's take appearances from the parties. Who's here with the South Carolina Public Service Authority, also known as Santee Cooper?
Thank you. Steve Pelcher, I'm Deputy General Counsel here. With me is Megan Driggers, Ashley Cooper, and Alex Brazell.
Thank you. And who's here for Central Electric Power Cooperatives, also known as Central?
Good morning. I'm John Jenkins, and I'm Chief Legal Officer for Central Electric Power Cooperative.
Thank you. Nucor Steel Berkeley.
Good morning, Madam Chair, members of the Commission. Rob Smith with Moore Van Allen on behalf of Nucor Steel Berkeley.
Thank you. Office of Regulatory Staff.
Good morning, Madam Chair. Nicole Given on behalf of the South Carolina Office of Regulatory Staff. Here with me today in the hearing room is Ben Muschin.
Thank you. As we go forward, I know that as attorneys, you're all used to standing, but I need for you to make sure you're speaking into a microphone. So you are welcome to stay seated and use the microphone at your table, or if you're more comfortable, you may go to one of the podiums that you can get to. We just want you to be comfortable in your presentation. So if you need to move, that's fine. But it is important to use the microphones so that our virtual commissioners can hear. And also I would note that in this proceeding, the commission has a consultant that we've hired. I think you're all aware of that, PA Consulting. They are monitoring this virtually, so they need to be able to hear as well as the public. So just let's make sure and I'm real bad about turning the microphone on and off, and I have to restart too, so understand that. Any preliminary matters before we begin? Anybody? Okay. Mr. Pelcher or Mr. Cooper, Ms. Driggers, who's up?
Thank you, Chair Belser, members of the Commission. At this time, South Carolina Public Service Authority calls Jane Campbell to the stand.
Ms. Campbell, I think we're going to put you down here. Ms. Joe, where do you want her to sit? Okay. And Ms. Joe, will you swear in, please?
You would raise your right hand, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? I do. Thank you.
Ms. Campbell, you may be seated. I'm going to ask you to turn that microphone on in front of you. You may need to pull it towards you a little bit.
Is that working?
Yes, ma'am. The little red light's on, so it should work. Just need you to put it in a position where you can talk into it.
Okay.
Thank you, ma'am. Thank you. Mr. Cooper?
Yes. Thank you, Ms. Campbell. Just for the record and purposes of the record, would you please state your name for the record?
I'm Jane Campbell.
And by whom are you employed and in what capacity?
I'm employed by Santee Cooper as its Senior Director of Resource Planning.
Have you prepared or caused to be prepared under your supervision direct testimony of 13 pages that was previously filed with the Commission on February 27th, 2023 in this docket?
Yes, I have.
Have you any changes or additions to your pre-filed direct testimony?
I do not.
And if I asked you the same questions here today, would your answers be the same?
Yes, they would.
Chair Belser, at this time, I move that the pre-filed direct testimony of Ms. Campbell be admitted into the record as if given orally from the stand.
The pre-filed direct testimony of Jane Campbell will be received into the record as if given orally from the stand.
Thank you. Ms. Campbell, have you also prepared or caused to be prepared under your supervision rebuttal testimony of 7 pages that was previously filed with the Commission on May 5th, 2023 in this docket?
Yes, I have.
Do you have any changes or additions to your pre-filed rebuttal testimony?
I do not.
And if I asked you the same questions here today, would your answers be the same?
Yes, they would.
Okay. Chair Belser, at this time, I move that the pre-filed rebuttal testimony of Ms. Campbell be admitted into the record as if given orally from the stand.
The pre-filed rebuttal testimony of Jane Campbell will be received into the record as if given from the stand.
Okay. And Ms. Campbell, did Santee Cooper enter into an agreement with the Office of Regulatory Staff, Central Electric Power Cooperative, and Nucor Steel stipulating the proposed guidelines meet the requirements of Act 90?
Yes, they did.
Did Santee Cooper file this stipulation on June 7th, 2023?
Yes, we did.
Chair Belser, at this time, I move that the stipulation among Santee Cooper, the Office of Regulatory Staff, Central Electric Power, and Nucor Steel, filed on June 7th, 2023, be admitted into the record.
The stipulation filed June the 7th in this docket, and I think it's about 30 pages without the cover letter, will be marked as hearing exhibit number 1 and received into the evidence of the case.
Thank you, Chair Belser. And we have hard copies should anybody need that, or if the court reporter would like. Okay, perfect. Thank you. Ms. Campbell, have you prepared a summary of your direct and rebuttal testimony?
Yes, I have.
Would you please deliver that summary at this time?
Of course. Good morning, Chair Belser and members of the Commission. In my direct testimony, I provide an overview of Santee Cooper, explain Santee Cooper's relationship with Central Electric Power Cooperative, and discuss how the program guidelines contained in Santee Cooper's application were carefully designed to align with the CPRE requirements contained in Act 90. Finally, I'll introduce Santee Cooper witness John Painter, who is also testifying in support of Santee Cooper's application in this docket, and he's participating virtually. Santee Cooper is South Carolina's state-owned electric and water utility. Santee Cooper was created by legislation as a rural electrification and public works project for the benefit of all the people of the state, for the improvement of their health and welfare and material prosperity. Santee Cooper is the state's largest power provider, supplying power for approximately 2 million South Carolinians, either directly at retail or indirectly through a wholesale power contract with Central. Central is Santee Cooper's largest wholesale customer, and the terms of Central's wholesale power purchase of power from Santee Cooper are governed by the Power System Coordination and Integration Agreement, which we commonly refer to as the Coordination Agreement. Central is a generation and transmission cooperative that provides wholesale electric service to each of its 20 member-owner distribution cooperatives, which are subject to long-term all requirements power supply agreements. Generally, Santee Cooper supplies the total power and energy requirements in the territory served by the 15 central cooperatives connected to the combined authority central system as of January 2013. The program guidelines Santee Cooper submitted in this docket were created based on our prior experience conducting a competitive procurement for renewable resources. These guidelines were further modified to ensure compliance with Act 90's requirements. The program guidelines will serve as a basis for future solicitations, but allow for specific future resource needs, technology advances, regulatory changes, and lessons learned. The program guidelines also account for Santee Cooper's relationship with Central. Specifically, the guidelines are drafted to allow Central to participate in a future CPRE. It is important to note that even if Santee Cooper identifies a need for a CPRE, Central can decide to opt out of any such procurement. Such a decision will have a material impact on Santee Cooper's need for a CPRE. Appearing with me today virtually is witness John Painter, who is the CEO and executive consultant with Infront Consulting. As explained in witness Painter's testimony, Infront assisted Santee Cooper with certain aspects of this program guidelines, including evaluation criteria and processes, and non-price evaluation factors. Santee Cooper selected Infront to assist with the 2020 competitive procurement solicitation. Over the course of that solicitation, Infront performed a number of functions at the direction of Santee Cooper, including coordinating communications with respondents and evaluating bids in tandem with Santee Cooper. Infront also provided input on the development of the 2020 procurement guidelines and assisted with items such as bidder qualifications and project qualifications. Based upon their knowledge of broader industry trends, Santee Cooper's prior experience with procurement and role in developing the program guidelines, Infront can testify to not only broader industry trends, but also to Santee Cooper's specific system. This concludes the summary of my direct testimony. In my rebuttal testimony, I addressed the concept of all-source procurement, as well as various ways to structure third-party CPRE assistance. With respect to whether or not to utilize an all-source procurement, it is important to note that this docket is limited to Santee Cooper's requirement to file a program for the competitive procurement of energy, capacity, and environmental attributes from renewable energy facilities. While Santee Cooper appreciates the debate taking place in the electric industry at large on the merits of all-source procurement processes versus renewable resource procurement processes, Santee Cooper believes that this application and Santee Cooper's CPRE program must adhere to the regulatory requirements specific to Santee Cooper's CPRE process. I also addressed the various forms of third-party assistance and involvement with the CPRE process. As a threshold matter, there is no regulatory requirement requiring any third-party involvement in the competitive procurement process. A third party may be selected for the limited purpose of facilitating stakeholder meetings and ensuring the transparent sharing of information. In such situations, the utility will have full responsibility for reviewing proposals and selecting winning bids in accordance with published guidelines. Alternatively, a third party may serve as a monitor. In this situation, the utility will be evaluating submitted proposals and selecting the winning bidders, but the monitor will ensure the utility follows its protocols and adheres to its published evaluation criteria. Finally, there may be some limited situations where a third party will administer the CPRE process, including the selection of bidders. This concludes the summary of my rebuttal testimony.
Thank you, Ms. Campbell. Chair Belser, at this time, Ms. Campbell is available for questioning.
Thank you. I believe under the stipulation that has been entered, all the parties have agreed to waive cross-examination unless there is something that needs to be clarified after commissioner questions. Is that correct?
That's correct.
And with that being the case, I'm not going to call on the parties for cross. I'm just going to go to the commissioners, but if you need to speak, just get my attention, okay? Commissioners, questions for this witness?
Madam Chair.
Madam Chair.
Commissioner Irvin?
Thank you. Ms. Campbell, how are you this morning?
I'm well, thank you.
Great. Welcome to the Public Service Commission of South Carolina. I believe this may be the first time you've testified before us.
Yes, it is.
Are you familiar with the South Carolina Code Section 58-31-227, subsection B, regarding this docket? Are you familiar with the statutory provision that we're working under?
Chair
And let me
Belser,
just read, if I can read a portion of it, maybe.
Commissioner Irvin, counsel is going to hand the witness a copy of the statute.
Thank you.
Thank you.
She has it.
Thank you, Mrs. Campbell.
I do.
Let me direct your attention to South Carolina Code Section 58-31-227, subsection B. Let me know when you find it.
I have it.
Thank you. The statutory provision that was passed by our General Assembly and signed into law requires that, in fact, it mandates that Santee Cooper must procure such reasonable resources subject to the following. One, renewable energy resources procured by the Public Service Authority shall be procured via a competitive solicitation process open to all independent market participants that meet minimum eligibility requirements. Does that statutory provision require Santee Cooper or the Public Service Authority to use the competitive solicitation process in this case?
Yes, it does.
And the second portion of that, section 2 of that provision says, the Public Service Authority shall issue public notification of its intention to issue a competitive renewable solicitation at least 90 days prior to the release of such solicitation. When does public notice, when is it given? It's required. I'm just trying to determine when it's given.
Right, so that's issued 90 days prior to the RFP.
Okay, and so that's something that happens after the commission approves it. Is that correct?
After the commission approves the CPRE program guidelines, yes, sir.
Correct. And under subsection 3 of that same statutory provision, I'm quoting now, renewable energy facilities eligible to participate in a competitive procurement are those that have a valid interconnection request on file and that use renewable energy resources identified in section 58-39-120F and may include battery storage devices charged exclusively by renewable energy, end quote. Are you familiar with that provision?
Yes, sir, I am.
Does that provision require and mandate that Public Service Authority use, quote, renewable energy facilities only?
No, it does not.
Okay. Tell me more about that. Can other resources be considered or just renewable?
Santee Cooper can consider any types of generation resources. The program guidelines here apply to renewable resources that we may be soliciting for and includes renewable resources that could include battery storage. And that's the only resources that this particular program applies to.
So in this particular program that's before the commission today, only renewable energy resources can be considered. Is that your understanding?
Yes, sir.
Okay. You'll be back before the commission in what's known as an IRP or proceeding later, and you'll be tasked with providing the commission with an integrated resource plan for coming year. But that's a separate proceeding, is it not?
Yes, sir, you're correct.
Okay. Let me go a step further and ask, you've made reference to a stipulation among all the parties. Do you have that in front of you? I don't happen to have a copy in front of me. Do you have a copy? I believe it's been marked as Exhibit 1.
Right. Yes, I do have a copy.
All right. And if you would, tell us whether that particular document has the signatures of all the parties in the docket. Have all parties consented and agreed to the stipulation?
Yes, sir, they have.
Have all attorneys of record also signed and agreed to the stipulated settlement agreement?
Yes, sir, they have.
Okay. Are you asking the Public Service Commission of South Carolina to approve the stipulated settlement agreement in this proceeding?
Yes, I am.
And are you aware of any party to the docket that opposes the stipulated settlement agreement?
No, sir, I'm not.
In fact, is it your understanding that all parties to the agreement have asked the commission to approve it as proposed?
Yes, sir.
And if there happen to be any modifications to the stipulated settlement agreement, I believe it provides in its terms that any party could withdraw from the agreement. Is that your understanding?
That would be my understanding.
Okay. Now, you've done this before at Santee Cooper, is that correct? You've had a prior experience, you and your staff, with a similar procurement program. Is that true?
Yes, sir. Santee Cooper has previously executed a competitive procurement of renewable energy. It was not under my direction, but I was at Santee Cooper when that took place, and I'm familiar with it and can speak to it.
Very good. About when was that, if you recall?
In 2020.
Okay. And at that time, you were not subject to the South Carolina Public Service Commission authority, were you?
No, sir.
That came later, is that correct?
Correct, with Act 90.
Right. And so let's direct our attention to Act 90. Does it say that the Public Service Commission shall approve? Is that the word that's used? Shall approve the competitive procurement of renewable resources, or words to that effect?
Yes, sir. I believe so.
Okay. Did you note that the authority does not necessarily believe that a hearing is necessary, but you're available to answer any questions about the stipulated settlement agreement today? Is that right?
Yes, sir.
What kind of in-house help did you have with the procurement proceeding that you used prior to coming before the commission in the 2020 docket? Do you know, did you have an independent consultant that worked with you to develop that program?
Yes, sir. Santee Cooper retained in-front consulting. Witness John Painter is participating in this hearing virtually. In 2020, in-front supported Santee Cooper in the development of the program guidelines, the solicitation, the evaluation of bids, and then the selection of the winning bidders, serving as our in-house consultant. In-front brought a lot of experience from the industry, knowledge of the industry that helped us as we went through this process, and also served as a third party to provide transparency in the process. They also helped coordinate the solicitation process with Central, who also participated in that solicitation.
Did you find that his professional assistance was helpful in the process?
Yes, sir, it was. In-front brought broad industry experience and guidance for Santee Cooper as we went through this solicitation.
And was it successfully completed?
Yes, sir, it was. Santee Cooper signed contracts with 4 different developers for solar projects at the completion of that solicitation.
Are those contracts in the process of being implemented?
One terminated, the others are in process.
Okay. And so are you planning on using the same consultant in the process that we're discussing today?
The process we would use for future solicitations, of course, would meet the program guidelines being presented today. We very likely would have an outside consultant in front or someone similar supporting that process as we go through.
are you planning, if the commission approves your request today and approves the stipulated settlement agreement, then would the next step be to try and, through a solicitation, engage an outside independent expert to assist you in the implementation of this program?
That is the plan today.
Okay. No further questions, Madam Chair. Thank you.
Thank you, Commissioner Urban. Commissioner Thomas?
Thank you. Good morning.
Good morning.
So it sounds like what we're talking about here does specifically relate to renewable energy.
Yes, sir.
And so let me ask a question. Are you the one that is heavily involved or responsible for the integrated resource plan?
Yes, sir, I am.
Okay. And previously you've used other planning processes, is my understanding.
Yes, sir.
And so how is that working now? Because before you didn't have to do an IRP, but now you do. And so you're still using the other planning processes. Just tell me how that works together, please.
Yeah, of course. So in the past, Santee Cooper used a very similar methodology. We used complex software to develop our future resource plan. The difference was that now we fall under Act 90 and we are required to submit that for the commission's approval.
Okay. So can you help me understand how this process can specifically identify that you need renewable sources as opposed to not renewable? How does it tell you that? Can you help me understand that?
Of course, yes. So the model, as I said, is very complex. It's Santee Cooper assesses our current resources as well as any future load needs and the pricing that's estimated for any new resources. And then we run the model and it can tell us what the most economic solution is for the future load needs. Solar, renewable energy is typically going to provide energy, much more than capacity. But when it's economical, it will, our runs will tell us that and determine whether we need to go forward with solar procurement or other renewable procurement, as the case may be.
Okay. And I think when this things got started, ORS believed that you should be looking at all source type procurement, but you've reached a stipulation agreement and they're part of it. So how did you all resolve that difference?
Right. So all source procurement is it's certainly a possibility. It's not something that is addressed by the CPRE program guidelines. And so that's our position on this.
Okay. So let me ask you what some terms mean. So what is meant by valid interconnection request? What is there? Can you help me understand what that is?
Okay. I am not an expert on the details of that program, but however, I'll tell you what I know. It is a participant, a developer would approach Santee Cooper and pay a fee to study what it would take to interconnect to our system and if there were any transmission upgrades necessary.
Okay. And can you help me understand what is meant by the adjusted levelized price?
Adjusted levelized price. Where are you finding that?
I think that might have been mentioned by Mr. Painter in his testimony. He may be the more appropriate person to ask.
I'll defer to Mr. Painter to answer that question.
Okay. And the same, what is meant by the most favorable risk-adjusted total cost?
Right. Yeah, let me defer that question to him as well. He can talk about the specifics of the program.
Okay. And PA Consulting is working with us, and they have issued some discovery questions, and the first set went out in December, and I think another set went out maybe a month or so ago. And they were very, very similar questions. Can you give me an update on what is the status of responding to the discovery?
Yes, Santee Cooper responded to those discovery questions, I believe, last week, the 17th. No, that was date received.
I believe it was June 6th. Is that right?
Thank you. Yes, June 6th.
Okay, well, I must have just overlooked that because I didn't see it on the DMS, but maybe I just overlooked that. Anyway, so that I think is all that I have at this time. Thank you.
Thank you, Commissioner.
Thank you, Commissioner Thomas. Commissioner Justin Williams.
Thank you, Madam Chair. Good morning, ma'am. How are you?
Good morning. I'm well, thank you.
All right. So I understand that this is a stipulation, and I want you to rest assured that my goal is just to ask questions to get as much information about what's going on here. It's not to get you to undo the stipulation or anything like that. Just questions. Does that make sense?
Absolutely, thank you.
Okay. And just to let you know the frame of mind I'm in, I just came back from the first phase of the Army's Command and Staff College, formerly known as ILE. So I've been studying national defense strategy, national security strategy and guidance, how to secure our country's future and way of life, so forth and so on, right? The way, in my mind, this relates to what we're doing here is that I want to make sure that South Carolina's energy future is secure, safe and secure. So that's the frame of reference that I have, and that's the place I'm coming from when I'm asking you these questions. Does that make sense?
Yes, sir, absolutely.
Okay. And so the law here, South Carolina Code, annotated Section 5838, 31227A, has been referenced several times. And as I read it, I take the responsibility, or I interpret the commission's responsibility as one that requires us to approve your CPRE program, a program that's in the best interest of Santee Cooper's customers. Okay. Is that your understanding as well?
Yes, sir, it is.
Okay. So walk me through how the program is in the best interest of your customers.
So, of course, competitive procurement of renewable energy. Obviously, it is intended to be a transparent process, so qualified bidders can participate and allow the market to let the preferred bids rise to the top. This certainly would be in the best interest of our customers to ensure cost-effective renewable energy. It goes without saying that once Santee Cooper has identified a need for renewable energy, we need to procure that need in order to maintain the power supply for our system. And then lastly, the approach Santee Cooper has taken is a PPA approach. The risk associated with development of solar projects then is placed on the developer rather than Santee Cooper. So this ensures that Santee Cooper is able to deliver those projects on time, on schedule, working through the developers.
Okay, thank you for sharing that. So I'm just going to repeat to you the information that I pulled out or that spoke to me in your statement. And what I heard was reduced risk, transparency, and the best bids for competitive or the best bids for renewable energy rising to the top. Okay.
That's fair.
And all of those being in the best interest for your customers. Okay. So it sounds like to me that there has been an acceptance by, whether it's by you or Santee Cooper, there has been an acceptance that the CPRE program is the way to go based on the law.
Yes, sir, it is.
Okay. Which is why you filed your program.
Absolutely.
Okay. So I want to transition us to some critical thinking. All right. Not to say that the CPRE program is not the way to go. Because I don't know. Maybe it is, maybe it isn't. I know what the industry says about it, but I just want to have a discussion with you to think critically about it. Has there been any thought that maybe the CPRE program is not the way to go, even though the law says what it says? That maybe the law, at the time, the law was accurate or on point, but maybe things have changed.
No, sir, I think it's appropriate. When I first read the requirements and the application we were preparing, it actually seemed very similar to the way Santee Cooper conducts business for procurement already. What this does, it brings forth a program that's transparent. It ensures the involvement of all qualified bidders with the notification requirements, and then closing the solicitation with a report to the ORS, I believe, to summarize the bids and report back is the feedback that's required to close the loop. Those are two new processes for us, but aside from that, it's comparable to any competitive procurement program that we've been using at Santee Cooper for other materials and labor and supplies.
Understood. And I'm going to ask a better question. You spoke to the framework of the program and some of the specific attributes of the program. I want to get to a more general basis for the program. Why is separating renewable energy for procurement away from other generational sources in the best interest for Santee Cooper customers? And to state it differently, why is a competitive procurement for renewable energy in the best interest for Santee Cooper's customers as opposed to an all-source procurement program?
Yeah, so once the need for specifically renewable energy is identified, a competitive procurement program allows for a transparent process that identifies the appropriate and best solution. All source is not part of the CPRE legislation and not part of this program. It's not off the table, but it's not part of the program guidelines that we have presented here.
Understood. And I want to be clear with you. I don't have an opinion on any of these things, but in order to go through our order of proof, if you will, or go through the facts, I think it's important just to work through this and walk through it slowly. So my colleague, Commissioner Thomas, asked you about the model and how you identify the need for renewable energy. Do you remember that?
I do.
Okay. So, and just to be transparent with you, I've done some studying on models and the electricity market. Okay. So would you agree with me that models can be manipulated?
I don't know if I would agree with that. The way we would work it is making our assumptions. Certainly your assumptions can be changed. But once you've made your assumptions, there's not much manipulation you can do with the model.
Okay. So the answer to my question is no, you don't believe models can be manipulated.
No.
Okay. All right. And so the assumptions, thank you for your answer. So the assumptions that you make and that you input into your models, where do those assumptions come from?
It depends. Santee Cooper uses many sources for assumptions that inform our integrated resource plan, industry standard databases, previous solicitations, previous estimates, consultants. We're getting into some of the details of an IRP. So I don't have those in front of me, the names of the different sources that we would have used, but there is a basis for what we put into our IRP.
Mm-hmm. Has there, in your experience, has there been a time where a model you used was wrong, to put it simply?
Not in my experience.
Okay. So in your experience at Santee Cooper, every time you used a model to make a decision or as a basis of your decision, it has turned out to be accurate?
Well, my limited experience in resource planning is just this last run of the model.
Mm-hmm. Well, I'm talking about all models, any and all models that you've ever used during your time at Santee Cooper as a basis for making a decision.
Can you restate the question?
Has there been a time in your experience at Santee Cooper or your experience at all? I don't know where you were before Santee Cooper. I would imagine you've been there for some time, but we can just keep it to Santee Cooper. Has there ever been a time where you used a model, assumptions were made, they were put into the model yielded whatever the results were used as a basis for making a decision, and then in hindsight, the decision based on the model was the wrong decision to make?
I think the answer would be, and speaking hypothetically, because again, I don't have direct experience with that, but if your assumptions were wrong, that could lead to an incorrect result.
Okay, that's fair. So what's the quality control in your assumptions?
Santee Cooper uses outside consultants, third parties that assist us with obtaining that information.
Okay.
So it's not a one point assumption. You're getting some data, you're validating it against other utilities, against industry, against prior experience. It depends on what assumption you're making as far as what you validate it against, but we try to use the most accurate data possible. And the other thing I'll point out too is, and again, we're getting into the integrated resource plan process, but we will evaluate sensitivities for key components of assumptions such as fuel pricing or load, for example. And so that minimizes the risk of an incorrect result if you're looking at what the result could be should some of these things happen. It's not all encompassing, but it's a very good determination and risk assessment of the decisions that you're making.
Understood. Thank you. Thank you very much. I'm going to digest some of your answers, and I may have some more questions or I may not. Thank you for your patience, Madam Chair.
Thank you, Commissioner Williams. Commissioner Carolee Williams?
Thank you, Chair Belser. Good morning.
Good morning.
I'm sure it's not easy to be there. It's also not easy to be here and formulate as logical questions as my colleagues have just asked. So I have a variety of questions. The first is, in 2020, did Santee Cooper or Central Electric bid into the CPRE process?
No, they did not.
Do you envision doing that going forward?
A self-build,
right.
It's not off the table, but that's not our current plan for solicitation. It's not an area of expertise that Santee Cooper has. And we certainly believe that using a developer-provided solution is going to be, as long as it's cost-effective and it shifts the risk off of Santee Cooper to the developer, which is beneficial for our customers.
If you, and I understood you're unlikely to, but it's not off the table. If you did, if either party did, would that change how you view the third party independent advisor? There are a lot of terms out there, but I think you testify that there's a monitoring function that you're likely to use. But if you all were to bid in, would that change how you would use in, I can't think of the name of the company.
In front.
In front.
Yes. So I'm not aware of a industry standard definition for an independent third party and what that entity would do. Infront has served as our under our direction in a previous solicitation, and we believe that their participation and the work they did for us brought transparency to the process. It brought industry knowledge to the process.
Mm-hmm.
And expertise in doing the same type of work for other companies. Our intention would be to use a consultant in that same fashion going forward, whether it would be a self-build or a solicitation.
I'll try to ask my question a little bit differently. If you are doing self-build, would that change at all how you viewed your third party and how you would use them?
It's a bit of a hypothetical because we aren't considering self-build at this point.
Right.
So I don't believe so.
Okay.
The experience they bring to the process is valuable, and I don't see that changing should we pursue a self-build option.
Okay. And I guess to put a finer point on it, what I understand is that there is an option when you are offering a self-build bid, that there's a greater level of independence that these third parties can have, so that anybody who is bidding in understands there is objectivity. And it's not like I think we've learned that there can be firewalls within Santee Cooper where one entity wouldn't know our bids are not obvious. And so I'm really asking, how would you address it? And I know it's hypothetical, but how do you address transparency and objectivity if you all make this unplanned decision to participate?
So you can really ensure a level playing field with posted procedures such as what we have before you today, a transparent process, allowing all qualified bidders to bid into it, and then a public publication of the results of that bid. I don't see a self-build precluding any of that. And this program does it. It's important to note that the utility must be involved in terms of the selection of the bidders. We know our processes, we know our plans, we know our needs, and we know our customers' needs and expectations. So it's important that we can't completely put a firewall between Santee Cooper and the selection of whoever is chosen to proceed. The focus should be on ensuring transparency of that process.
And in my questions, have you answered from either Santee Cooper or a Central perspective, or just with Central in mind? Would Central even participate if you're able to answer that question as in a self-build kind of way?
I really don't know.
Okay.
I'm speaking for Santee Cooper.
I understand.
Right, but we would entertain any sort of arrangement with Central that would benefit both our organizations. We'd be open to that.
So the timing of your IRP submittal and the CPRE program is challenging. It's good that it's coming so soon after this and that we've got this. Is there anything you'd like to add to your testimony since you have filed your IRP submittal in terms of, like, you may not be able to answer this, but based on what you've submitted, if we were to approve that, would you have a need to use a CPRE process for renewable energy?
Our plan would be to solicit following approval of the CPRE. Our IRP that's been submitted to the commission has identified a need for solar, as did our previous planning process in 2020, the IRP. And there is definitely a need for additional energy on our system. So we are awaiting approval of this program to conduct a solicitation for solar. We're ready to get it on our system. We're ready to increase the magnitude on our system and are excited about growing solar on Santee Cooper's system.
So would you start the CPRE process prior to the IRP decision?
That's the plan.
Okay.
Yes.
Can you tell me more about why that makes sense to you all from a business perspective?
The need was identified not only in the 2023 IRP that was just submitted, but also in the 2020 IRP, and certainly the growth on the load in our state dictates the need for us to add additional resources. So we believe that following approval of the CPRE program that we could begin a solicitation for solar, and that would be our intent. The time required from solicitation and awarding bids to construction is years, and we are ready to get more solar on Santee Cooper's system, and certainly have identified a need for it in both this IRP and the previous.
Okay. Relative to that, does Santee Cooper verify that it seeks the lowest cost and most reliable source of generation when a need is identified?
Low cost, most reliable, and least risk.
That's a yes?
Yes, ma'am.
Adding least risk.
Least risk.
How would you define risk?
Well, I've told folks that the day after you submit an IRP, it's going to be wrong, right? Because your forecasts change. But being able to determine how a change could potentially impact the outcome is important in making a recommendation. And if a change does not change your decision, then you've made a least risk decision. So risk is not just the potential for some of your basis to change, but the potential for that change to impact your decision. And whenever you can minimize that, you've got a solid decision going forward.
In the application, you probably don't need to look at it, but it's page 12, and it's where you identify the evaluation methodology. And are all of those equally valued, or do you have, in the program, will you value some more than others? And if you do, what would those be? And that's reliability, which is your number one, and then readiness, viability, location, and on and on.
I would have to say it depends. So it'll depend on the individual solicitation as far as what is most important at that particular time and for that particular need. So that would be identified when we, once we notified that we were going to solicit and establish the specific program guidelines for that solicitation. That would be identified at that time.
So it would be clear to applicants
Yes.
so this structure gives you flexibility to tailor if you do points associated with these things so that anybody bidding in would know you were valuing reliability more, or you were the resource type was most important, or is that what you're saying?
Yeah, that's correct.
Okay.
Thank you.
Do you use points just out of curiosity, or do you have another tool for how you value these?
Well, this will be the first time going through that, so I imagine that structure will be, or not I imagine, that structure will be defined when we do our first solicitation. Points may be a good way to do it.
Okay. Exhibit A of the application. I think I have two questions about it, and my style, I guess, is more to just ask you the questions and then let you respond as you wish. But you'll see my naivete in understanding the process. My first question is: it looks like there's 8 weeks between when you put out the RFP and when the last day to submit proposal under RFP. Is that true?
Yes, ma'am.
And is land procurement a part of this? Would they need to have the land under ownership or under first right of refusal, or am I overthinking this?
No, I think that's probably it's going to be specific to the developer, but if they're going to submit a proposal, they're going to have the land either leased or owned that they would build it on.
Okay. It's just a short turnaround to have the land under ownership, but it means you've got confidence that they can make it.
Yeah, and now, they'd have to be qualified, right? So,
right. And then, as I was reading, and I understand the variety, the way that the options that you have for going forward if Central chooses to participate or if they don't, but how does that relate to Exhibit A? When would Central make their determination, and how do you know? Because that's need-based. Mm-hmm. If they decide they're not interested, right, then it changes what you need. So just talk some about how that would impact Exhibit A.
Right. So the central decision would have to take place before going for a solicitation.
Okay.
So we would propose a resource for the system to Central, and then they would determine if and how they wanted to participate in that resource. If they were to opt into it or opt out, even if they opt out, they could still jointly procure that resource with us.
Mm-hmm.
But all that would have to take place prior to the solicitation because it could change the magnitude, right?
That makes 100% sense. I want to just reiterate what Commissioner Williams said, that I think our primary responsibility is to determine if this is in the best interest of your customers. Do you have any more you want to add that you thought about after reflecting on what you said in that question and answer?
No, I don't think so.
Okay. I wasn't looking for anything. I just wanted to be sure. I am wrapping up. Like him, I might have another question, but I really appreciate what you've added to what I understand.
Of course. Thank you, Commissioner.
Commissioner Caston.
Thank you, Madam Chair. Good morning, Ms. Campbell.
Good morning.
Don't know why I'm losing my voice right now, but excuse me while I take a sip. Hopefully that'll work. I had just a few questions, but hearing some of the other questions generated questions, and that kind of want to replow a little bit of ground, if it's okay. I think a response to Commissioner Justin Williams, that you didn't believe models could be manipulated. Is that correct? Is that what I heard?
My response to that was, the model's the model. The assumptions are what could be changed to produce a different result.
So, with every model, the assumptions are very important, correct?
Yes, absolutely.
And if the assumptions are faulty or biased, you could get faulty or biased results from a model, correct?
Correct.
You don't have to look these up, but on page 1, lines 16 through 18 of your direct testimony, it clearly, your experience and role, you're very familiar with Santee Cooper's long-term resource strategy and development of their IRP. Is that correct?
I would say fairly familiar with it.
Relative to your comments on page 3 of your rebuttal, where you talk about IRPs and other alternative planning processes would occur outside. What other alternative planning process would occur outside of the IRP and the IRP annual updates?
So when I said that, I was thinking about the 2020 reform plan that Santee Cooper conducted and that identified a need for additional renewable energy on our system. I don't preclude other processes, but that was the one I was specifically thinking about.
Okay. So you're talking about in the past, but not now and going forward necessarily. I am so sorry.
That's okay.
And this question was, I think, asked by Commissioner Thomas earlier, and I just want to make sure I heard that right. Relative to discovery, Santee Cooper's responded to discovery from everyone they were supposed to respond to. Is that correct?
Yes, sir.
Does Santee Cooper use a competitive procurement process for all sources and technologies of new or added generation?
The competitive procurement process here is for renewable energy, right? So Santee Cooper uses a low bid process for procurement of other materials, labor, supplies, but it is not under the purview of the commission. The only one here is the renewable energy.
I'm not sure I understood the answer. Let me ask it again. No matter what the generation source is, does Santee Cooper use a competitive procurement process, or do you only use a competitive procurement process? You're shaking your head. Okay.
Yeah. So I'm an engineer. So I need to go buy a pump. I go to procurement. I say I need a pump. Here's my contract, or here's my request. They would issue it, and I give them terms under which I would make a decision about which pump I'm going to buy. And I'm required to show that that is competitively the best decision. It's very similar to the terms that we have here.
And I get that, we're talking about pumps, but I'm talking about just generation in general. In other words, I certainly can't tell Santee Cooper how to run their business. That's your guys' job. But you supply electricity. And I'm not sure exactly how you decide that or why you decide that. You know, do you do it based on, well, we want the most reliable, the least cost? You know, is that generally?
I would say yes. So Santee Cooper, as a public agency, is we're passing all of our costs through to our customers. So we are certainly incented to provide the least cost, most reliable, least risk to our customers for any kind of power procurement. The evaluation of what that reliability or risk could be qualitative. Cost would not be, but we would take all of those things into account in making a decision about what resource to procure and how to proceed. But at the end of the day, we're going to put our customers first in terms of what is the best solution that's going to provide them low cost power that they can depend on. Does that make sense?
Yes. And again, thinking about Commissioner Justin Williams' questions relative to the process. I think what I'm hearing is that Santee Cooper, regardless of the generation source, type, technology, uses a competitive procurement process to acquire the most reliable, least cost generation. Is that a true statement?
That would be fair to say.
Then, and I'm, other than the fact that this is in the statute, what does it matter? If that is the process Santee Cooper uses, why a competitive, it sounds like I'm hearing that competitive procurement is not for only renewable resources at Santee Cooper, it's for every generation source. Is that correct?
I would believe that to be the case. I haven't been involved in every power purchase that Santee Cooper's done, but to my knowledge, that would be the case.
Okay.
Am I answering your question?
I think so. I'm having to ponder it also, but
Okay.
Yes, ma'am, I believe so.
Okay.
This was kind of asked, I think, before, but it was relative to, I think, Mr. Painter's testimony. And I'll ask you this question since you're the one that's very familiar with the planning process, the RFPs, and I guess the CPR process. Does Santee Cooper consider and use the aggregated levelized cost of selected projects for the CPR portfolio to confirm costs are comparable to the assumed cost data used in the approved IRP?
I'm going to kick that question to Witness Painter, as he is more familiar with the details of the program than I.
Well, okay, I'll accept that, but if you're very involved with the IRP, the process, which also involves modeling and assumptions and everything else, would that data, those assumptions for the cost in your IRP, I guess, the previous one, I don't know, I guess the IRP said you need X amount of this generation. In this case, you were referencing solar in this particular hearing. There were some assumptions, I assume, in that IRP, and in the models for what those costs would be. Correct?
Yes, correct.
So in this process, would you not be aware or involved with whether the values or cost or levelized cost you're getting now from these RFPs, solicitations and everything are comparable to what I'm assuming you helped direct put in the IRP?
Yeah, absolutely. So that's very fair to say. If we could compare bids in a competitive procurement process back to the IRP and see how they match up with the assumptions, could make a decision if they're better or worse, make a decision about how to proceed or not proceed, as the case may be, and then use that information to better form our assumptions for the next time we run that model.
So I think I heard you say Santee Cooper, you could use that information. You could doesn't mean that you have so far or to date on the previous projects.
Witness Painter may be able to speak to the previous solicitation, the details of that, and
Okay.
how that matched up with the IRP. Just
Good
because
enough.
he was in the weeds on that one as I was not.
I understand.
Yeah.
And hopefully I'll remember to ask that.
Mm-hmm. You know, at the end of the day, we would want to make sure that it's still a benefit to Santee Cooper's customers, and that would be one way to do it, is to make sure those bids are at or below what was used in the IRP.
Sounds good, because if I'm understanding everything correctly, the whole purpose of all of this is to get the best value, the least cost, the most reliable, just the best stuff for the customers. Not just do something just to do it, correct?
Oh, absolutely.
I think that's all the questions, but if I think of something before I step down, I'll let you know.
Thank you, Commissioner.
Thank you, ma'am.
Commissioner Justin Williams, do you have a follow-up?
Yes, ma'am.
Please go ahead.
Thank you, ma'am. All right. I've let some of your answers digest now, and I'm ready for the next course. When you identified the need for renewable energy through the IRP, once that that need is identified, help me understand what, if any, benefit using an all-source procurement program would provide in a scenario where you've identified a need for a specific generation source.
So the all-source procurement is typically focused on capacity, whereas renewable energy is typically focused on energy. The CPRE program is it does not require an all-source procurement. We would have identified a need through our IRP or another planning process for a specific type of energy, and then we would solicit for that specifically. We're not ruling out all-source procurement, but this program specifically does not require it for renewable energy.
I understand. And so the only benefit of using all source, once you identified the need for renewable energy, would be that process would include capacity. Is that what I'm hearing? In addition to energy.
We could use all source for capacity. I can think of circumstances where we may do that, particularly where two different resources are similar in price. But you have to consider the attributes, right? So the attributes of solar are going to be very different than, say, the attributes of wind or, combined cycle unit. So when you're soliciting for renewables, you're soliciting for solar or for wind, something specific.
And so when you go through that line of reasoning, I don't understand how all source procurement would be beneficial if you're looking for specific generation.
I don't for renewable energy, because we've identified a specific need at a specific location and a specific capacity or specific magnitude, megawatts magnitude, and then soliciting for that, I think an all source procurement would not add any benefits. I'm not ruling it out for a capacity addition, another case, but that's not what we're discussing here for the CPRE program.
Were discussions like that? Well, let me ask it this way. How did you work with, I think, is it Infront?
Yes, sir.
How did you work with your consultant when considering industry standards, practices, and building your program that you presented here? Was that discussion had about all source versus competitive procurement of renewable energy?
We didn't address the all source procurement in the program because it wasn't called for in the statute.
Well, not in the program.
Yeah.
I'm just talking about the discussion. Like when you're talking shop and you know, in the initial phases.
The times we've discussed all source procurement would be for capacity additions where the costs and attributes of the resources are very similar. One example would be batteries versus combustion turbines. And when we did our IRP, those costs were very similar. You could switch batteries for CTs and achieve the same result. So that's an example where we may use an all-source procurement. We have this need, these attributes. What would be the best price for our customers? Where the system could tolerate it. That's an example of where they could tolerate it.
All right. Thank you for those examples. You helped me out greatly.
Okay, thank you.
Good morning, Ms. Campbell. How are you today?
I'm well, thank you.
I just have a couple of questions, if you don't mind. Do you still have your copy of the statute 5831-227?
I do.
And in subsection A, where it talks about Santee Cooper filing for approval of the program and what the commission, with regard to commission granting, may not grant approval unless the commission finds and determines. Would you look at the next sentence and you agree that commission has continuing oversight and approval authority over all aspects of any approved program?
I do agree.
Okay. I don't know that that's going to come into play, but should there be an issue that arises, we could come back in and need to have further discussions. Would you agree with that?
Yes, ma'am.
Okay. I understand from your testimony that at this point, Santee Cooper has not identified any self-build that they would participate in the bid process for the CPRE. Is that correct?
No, we have not at this time.
At this time, and I understand that's subject to change. However, well, let me take a step back. The stipulation approves the program as filed by Santee Cooper. Is that correct? As filed in the application.
Yes.
And really, what we've got here is these broad parameters that any solicitation for renewable energy would conform to. Is that correct?
Correct.
And depending on what Santee Cooper's needs are, what you've identified as needs through the IRP or another process, the specifics of the IRP, the fine details that everybody must adhere to submit a bid would be filled in. Is that correct?
Correct.
Okay. And if one of those specifics allowed for Santee Cooper to also bid, or an affiliate of Santee Cooper, would there be protections so that with regard to evaluation of the bids or other protections so that everybody bidding didn't feel like Santee Cooper had a inside track, so to speak.
Yes, I understand.
Okay.
So were that to happen, we would specify those in our RFP and how those bids would be evaluated, and would have to be clear about the specifics that would be considered for all bids.
And where I'm kind of going with that is I know that with the term independent administrator and independent evaluator and third party administrator, these terms kind of get thrown around, and I recognize there's some nuances in it. But if it was a situation where Santee Cooper decided that they wanted to also bid into the process, would that be a consideration as perhaps using a third party administrator to judge the bids so that it didn't look like Santee Cooper had a thumb on the scale?
We could certainly involve an outside consultant, and I would see that role being defined when we issued the RFP about how they would be evaluated.
And I'm not saying, don't get me wrong, I'm not saying that Santee Cooper would have a thumb on the scale, but things not only have to be right, they have to look right.
Right.
Especially when we're dealing with these bids. So would that be something that y'all would take into consideration in the details?
Yes.
Okay.
Yes.
And I understand that's hypothetical because there's not been that any at this point. Santee Cooper's not looking. Y'all like the idea of shifting the risk there. So
well, we don't have a development arm. We don't have a solar build company.
One of the requirements under subsection B is that is number 3, and renewable energy facilities eligible to participate in the competitive procurement are those that have a valid interconnection request. I take it that at this time there are interconnection requests, and there's probably a queue of interconnection requests that y'all have a list of somewhere. Is that correct?
Yes, that's my understanding.
Okay.
Not in my area, but yeah.
I understand. So for someone to bid, they have to be in that queue based on the statute.
As either in the queue or part of the cluster process.
Okay.
Which I think would also be
So,
considered.
and I'm kind of following up on some of Commissioner Carol Lee Williams' questions about the land. I mean, if they're in that queue, they've already staked out a location or where they're talking about where they would propose to put a facility.
Yeah, it would be location specific as far as where they would tie into our system. So yeah, they would have to know where they're going to build.
They would have some access to property somewhere around there. Is that correct?
They should.
Okay. All right. You talked about with Act 90 that Santee Cooper must now submit their IRP for to the commission for approval, and y'all have already submitted that, and that one's in the process. But prior to that, Santee Cooper still had to prepare an IRP, did they not?
That's correct.
And they filed it with the Energy Office.
That's correct.
So the IRP process is not a new tool for Santee Cooper. It's something that's been going on for years.
That's correct. I would say the level of detail and scrutiny is gone up, but we have been familiar with integrated resource planning for decades.
Okay. Well, that level of scrutiny and detail is because a lot of us are learning on the fly too. So we're trying to understand what's being presented as much as anything. But Ms. Campbell, thank you for answering my questions. That's all I have.
Thank you, Chair.
Looking down the bench. Mr. Cooper? Any redirect?
Thank you, Chair Bell. So I may just have just one or two.
Turn that microphone on, please.
Can you hear me now?
Yeah, thank you.
Sorry, I may just have 1 to 2 very short questions. Thank you, Ms. Campbell, for your testimony. You recall you were asked some questions about if a hypothetical, if Santee Cooper were to participate in, say, a self-build or participate in a CPRE. The guidelines, and was your testimony was it's just important to have guidelines and have transparency. Those were key parts. Is that a fair statement?
That's correct.
So one way to address this would be to Santee Cooper could have a transparent process where they inform participants that employees who participate in evaluating bids will be walled off from employees who submit bids or participate in bids. Would that be an option to Santee?
Yes, that's a great option.
And so and you were asked about there being multiple ways to have a third party involved, is that right?
Yes.
So could you also have a situation where a third party could even be a monitor, that it would allow Santee Cooper to evaluate the bids, but the monitor's role would be to verify that they monitored the situation and there was no unfair advantage and that Santee Cooper adhered to the published guidelines? Is that an option?
Yes, that's an option.
Okay. And another option would be an independent administrator was identified as well.
Yeah, that would be another option.
So there are a number of ways. Okay. You were also asked a question about planning processes and alternatives to an IRP. You could have a situation, hypothetically, and I'm just trying to come up with an example, but when you say an alternative or other similar alternative process, would it be possible that a utility may decide to retire a plant and commission a group to have a planning process to say, what are our needs on our system? How does this work with our transmission needs? How does this work with our generation needs? And that too could be an alternative planning process whereby a utility may take action or identify an all source procurement or a CPRE for the replacement of that plant. Is that a fair example?
Yes, that's a good example.
And then finally, on a model in the inputs are best case, they're informed inputs, they're studied inputs, but it's certainly possible that, say, pricing inputs may vary from actual market conditions in which you hear the market will bear. Is that fair?
Yeah, that's definitely correct.
Okay. Thank you very much. Chair Bell, I have nothing further.
Thank you, Mr. Cooper. Commissioners, anything further of this witness? Ms. Campbell, thank you for your testimony this morning. You may stand down.
Thank you, Chair Bowser.
We've been going about an hour and a half. Let's take a 10-minute break. Let's return at 11:40. Thank you. Good morning. Welcome back to the Public Service Commission. We will continue with the hearing in docket number 2022-351-E. Let's take a roll call of commissioners. With us virtually, we have Commissioner Irvin and Vice Chair Powers. Present in the hearing room, we have Commissioner Justin Williams, Commissioner Thomas, Commissioner Carolee Williams, Commissioner Caston, and Chair Belser. Mr. Cooper, next witness, please.
Thank you, Chair Belser. At this time, the company would call John Painter.
And Mr. Painter's virtual.
Yes, that's correct, Chair Belser.
Okay. There he is.
Good morning.
Good morning, Mr. Painter. I'm going to ask that the court reporter swear you in as a witness. Just a second.
Mr. Painter, if you would raise your right hand, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Thank you. Good morning, Mr. Painter. Mr. Painter, for the record, please state your name.
John Painter.
By whom are you employed in what capacity?
I'm the CEO of Infront Consulting and serve as an executive consultant providing services to clients.
Have you prepared or caused to be prepared under your supervision direct testimony of 20 pages that was previously filed with the Commission February 27th, 2023 in this docket?
Yes, I have.
Do you have any changes or additions to your pre-filed direct testimony?
In reviewing the testimony, I realized our address has changed since I filed it. Our new address is 4767 New Broad Street, Orlando, Florida 32814. Otherwise, I have no other changes.
Thank you. And if I asked you the same questions here today, would your answers be the same?
Yes, they would.
Have you prepared or caused to be prepared under your supervision one exhibit labeled as Exhibit 1, JFP-1, that was previously filed with the Commission as an attachment to your pre-filed direct testimony in this docket?
Yeah, yes, I have.
Do you have any changes or additions to your exhibit?
No, I don't.
Chair Belser, at this time, I move that the pre-filed direct testimony of Mr. Painter be admitted into the record as if given orally from the stand.
The pre-filed direct testimony of John F. Painter will be admitted into the record as if given orally from the stand.
And Mr. Painter, have you prepared a summary of your direct testimony?
Exhibit. Exhibit.
Oh, yes, and I also ask that his exhibit, which has been marked, and I apologize, exhibit number 1, JFP-1, be admitted into the record.
Mr. Painter's pre-filed exhibit noted as JFP-1 will be marked for identification and admitted into the evidence of this case.
Thank you, Chair Belser. Mr. Painter, have you prepared a summary of your direct testimony?
Yes, I have.
Okay, would you please provide it at this time?
Good morning, Chair Belser and members of the Commission. In my direct testimony, I described Santee Cooper's pre-Act 90 RFP process for procurement of solar power and the guidelines included in Santee Cooper's application that Santee Cooper proposes to use for competitive procurement of renewable energy, or CPRE, under Act 90. As Santee Cooper witness Campbell testified earlier, Santee Cooper's prior experience conducting a competitive procurement for solar energy served as the basis for the proposed program guidelines. The 2020 RFP solicited proposals to sell, under terms of a PPA, output and other attributes from solar projects having a total capability to produce energy during peak solar conditions or installed capability of up to 500 megawatts, and requested alternative proposals for developers to add battery storage systems to their proposed projects. Further, the procurement process was designed to allow Central to participate in the evaluation of responses received, identification of most attractive submittals, and the selection of winning bids. 6 months prior to the RFP process, Santee Cooper communicated its intent to launch a process to procure solar power in the second quarter of 2020 through what was called the 2019 RFI process, which informed the market of the volume of solar power Santee Cooper planned to procure, key terms of the PPA, and planned evaluation processes and criteria. The 2020 RFP accounted for participant feedback and information gained through question and answer processes that occurred under both the 2019 RFI and the 2020 RFP. The 2020 RFP statement of requirements, preferences regarding projects, and PPA terms reflected clarifications and refinements that resulted from questions received from respondents to the 2019 RFI, input received from Central, and further review by Santee Cooper and Infront Consulting. The interaction process during the 2020 RFP was very extensive. Between the June 5th date the RFP was published and late July 2020, respondents were provided the opportunities to submit questions based on their review of the RFP and the pro forma PPA. Infront Consulting consolidated the questions received from all potential respondents into 59 unique questions, excluded information that would identify potential respondents, assisted Santee Cooper and Central in preparing responses, and provided the questions and answers to all parties that had requested the 2020 RFP. This highly interactive process was beneficial to all parties involved in the 2020 RFP process. Santee Cooper developed and filed for approval the proposed guidelines that serve as the basis for a CPRE. The proposed guidelines also allow for Central's involvement and input. Central's involvement is important to achieve the best result from the competitive procurement process and economies of scale in procuring renewable resources for the combined system, and supports the processes provided for under the coordination agreement. These guidelines will be further refined to meet a specific need identified by Santee Cooper. The following provides an overview of the filed proposed guidelines developed in compliance with Act 90's requirements. Renewable energy resources procured by Santee Cooper must be procured via competitive solicitation process open to all independent market participants that meet minimum eligibility requirements. 2, Santee Cooper must issue public notification of its intention to issue a competitive renewable solicitation at least 90 days prior to the release of each solicitation, including the proposed procurement volume, process, and timeline. Renewable energy facilities eligible to participate in a competitive procurement are those that have a valid interconnection request on file and that use renewable energy resources identified in section 58-39-120F and may include battery storage devices charged exclusively by renewable energy. In addition to the 90-day notice required above, section 58-31-227C requires Santee Cooper to issue a public notice at least 45 days prior to each competitive solicitation. Such notice must include 1, a pro forma contract to inform market participants of the procurement terms and conditions. The pro forma contract will include standardized and commercially reasonable requirements for contract performance security consistent with market standards. Excuse me. Define limits and compensation for resource dispatch and curtailments that limit uncompensated curtailment to a specific portion of estimated annual output. A bid methodology that assumes all bids are treated equitably, including price and non-price evaluation criteria. Non-price criteria will at a minimum include consideration of diversity in resource size and geographic location. Interconnection requirements and study methodology, including how bids without existing interconnection studies will be treated for purposes of evaluation. Items D and E within section 58-31-227 require winning bids to be selected in accordance with the published evaluation methodology, while requiring Santee Cooper to submit a final report to the commission summarizing the results of the solicitation. The program guidelines ensure that any subsequent competitive solicitation fulfills these mandates within Act 90. Lastly, the proposed guidelines leverage Santee Cooper's prior experience with competitive procurement and provide a framework for future competitive solicitations in compliance with Act 90. Once Santee Cooper identifies a need for renewable resources that would justify the initiation of a CPRE. In my opinion, a CPRE process consistent with the guidelines proposed by Santee Cooper can be expected to serve the interests of Santee Cooper's wholesale and retail customers, including Central, by achieving effective, robust, and fair competition among parties interested in supplying renewable resources to the combined system. The guidelines also provide a framework in which Santee Cooper and Central would continue to cooperate in procurement of renewable resources, as was done through the 2020 RFP process. This concludes the summary of my direct testimony.
Thank you, Mr. Painter. Chair Belzer, at this time, Mr. Painter is available for any questioning.
Thank you, Mr. Cooper. Commissioners, questions for this witness? Commissioner Justin Williams.
No questions at this time.
Sorry, I thought I saw your light. Excuse me. Commissioners?
Madam Chair.
Commissioner Thomas.
Thank you. And thank you, Mr. Painter. Appreciate you being with us today. So how long have you been consulting with Santee Cooper?
Most recently, since 2016, but I've been involved in some Santee Cooper assignments dating all the way back to the 1980s.
Okay. So you have a long history, obviously, with Santee Cooper. So you basically, would you consider yourself as having been an independent outside consultant in the 2020 process?
Yes, I would.
So what would you think would be some of the important components of being independent outside consultant versus just a consultant or inside consultant? Any thoughts on that?
Well, in the case of the 2020 RFP, Santee Cooper asked us to approach the project with a level of independence that would assure that all the bids, you know, were considered fairly, and that would allow and provide for full cooperation with Central throughout the RFP process. So they asked us to really work in an independent fashion to help fashion the RFP, coordinate with Central, coordinate with the potential respondents, evaluate the proposals, advise them about selection of the best proposals, and help with the PPA negotiations with the best respondents.
Okay. And do you believe that in the future that you could be an independent outside consultant and work fairly and impartially with all participants?
Yes, sir, I do.
Okay. So let me ask for a little bit better understanding of a couple of the terms that I believe that you used in your testimony, and one of them was adjusted levelized price, and another was most favorable risk adjusted total cost. Can you help me get a little bit better understanding of what those terms mean?
Yes, sir. As we used it in the 2020 RFP, for instance, adjusted levelized price was intended to put all proposals on a common footing, allow an apples to apples comparison. For instance, some proposals included a levelized price over the term of the PPA, 15 or 20 years, or in a few cases, 25 years. But other proposals proposed a starting price in year one escalating over the term of the PPA. So the first step was to levelize all those prices to allow them to be more easily compared. A little bit later in the process, adjustments then were made to the levelized price to account for differences in other costs that would be incurred by Santee Cooper and ultimately by Central between the proposals. For instance, one proposal might have a very significant impact on the transmission system that would require upgrades, the cost of which ultimately would be borne by the customers on the system. An adjustment was made to include the cost of those upgrades on a levelized basis in the adjusted levelized price. Another example was some respondents did not have a full view of what the interconnection costs of their projects would be. So they responded that their price would cover up to X dollars of interconnection cost, and above that level, the buyer would have to bear those costs. So we, working with Santee Cooper and Central, developed allowances for the additional interconnection costs that might be incurred under that proposal. So those are just two examples of the adjustments that were made to get to an adjusted levelized price.
Okay. What about the risk adjusted total cost? You mentioned most favorable risk adjusted total cost. So what is that concept, if you can help with that a little bit?
It was a concept of identifying the uncertainties involved in a proposal and trying to quantify the range of costs that could result from those uncertainties. And going back to the discussion of interconnection cost, in some cases, the answer was the interconnection cost could range from X to Y. So there was an uncertainty there. And so that presented a risk that we didn't fully understand what the levelized cost would be of that particular proposal. So we had to consider that there was a risk that the levelized cost could turn out toward the high end of that range. And that should be considered in deciding whether to select that proposal or not.
Okay, thank you. That's all I have at this time.
Thank you, Commissioner Thomas. Commissioner Caston?
Thank you, Madam Chair. And good afternoon now, Mr. Painter.
Good afternoon.
I guess going back to the previous questioning and thinking some of the questions that were asked of Ms. Painter. Did, I guess, the previously referenced RFP did the RFP or the process consider all technologies or just solar battery?
It was primarily focused on solar power. We also did ask and offer the opportunity for respondents to offer alternative proposals that would also include battery, adding battery to their project. But that was to be considered an alternative, not their primary proposal.
So the previous projects, I think there were 5 in the either application or your testimony, I can't remember now, that were selected. So the need for, I think it was 500, 450, whatever megawatts of generation, that need was determined from Santee Cooper's whichever IRP. Which IRP would that be?
Well, that particular need was the outcome of the studies that developed the reform plan in 2019 for Santee Cooper. And as a result of that study, a large need for solar power was determined over the next several years. And the 2019 RFI and 2020 RFP were structured to provide a portion of that need.
Okay, it's kind of all running together again. I mean, at least for me. Now, the study you're referencing, this was a 2019 study? Or what?
Yes, sir.
And who performed this study?
In-Front Consulting worked with Santee Cooper staff to perform the power supply study I referred to.
And did this study, in working with Santee Cooper, identifying additional generation sources needed, did it consider all sources, or was it just predisposed, or could just we're going to look just at solar batteries?
No, sir. The studies were a long-term planning exercise that determined that the Winya coal station should be retired. There should be new resources added over time, including solar and natural gas combined cycle and other resources. So it was a long-term planning study, starting with all the plausible alternatives, considering all the plausible alternatives, and determining what the right portfolio should be going forward.
Okay, was that right portfolio determined on reliability, least cost, or we want some of this, some of that, some of this?
It was, I wouldn't say it was least cost. I would say that it was the most attractive portfolio overall, considering cost, various risk factors, and various qualitative measures.
Various risk factors and various qualitative factors. That sounds, I mean, I understand the words, but I mean, it's not real defined as far as, but let me move on. You said least cost wasn't the driving factor in all these. Relative to the coal retirement, excuse me. Oh.
Just a second. He's back? Okay, keep going.
Can you hear me, Mr. Painter?
There he is.
Can you hear me okay?
Okay, we can't hear Mr. Painter.
Happened to me last week, I understand.
We're going to stand at ease. We're not going to leave the room while they get the witness back, but we are going to stand at ease, so they'll put a slate up. Just a moment, please. We'll return momentarily. Good afternoon. We are back with the Public Service Commission in the hearing in docket 2022-351-E. We had a little technical issue that has been corrected. All commissioners are present, and Mr. Painter is on the witness stand, and we are in questions from Commissioner Caston. Commissioner Caston, please continue.
Thank you, Madam Chair. Mr. Painter, you can hear me okay now, correct?
I can hear you, but I can't see you.
You're
That's
not missing
coming.
much.
That'll come. Just take a second.
Okay. Okay.
Okay. You can still hear me, correct?
Yes, sir.
Okay. You had mentioned the Winyah facility, I guess the coal facility. Was that in the 2019 planning? I mean, was that part of that planning process?
Yes, sir.
So relative to that, I'm assuming looking at early retirement and replacing that lost generation with something else. Is that coal facility, I guess when it was studied, however it was studied, was it determined that the useful life of that facility is up, it has no more useful life in it?
I think most of the time, a power plant is retired when there's more economic alternatives than continuing to operate it. The study that was done in 2019 was aimed at finding the lowest risk-adjusted cost portfolio for Santee Cooper's customers, the combined system. And we did studies with continuing to operate Winyah, retiring Winyah, continuing to operate Cross, retiring Cross, and all different, quite a few different permutations. And the result of those studies was that the portfolio cost could be lower if Winyah was retired than if it continued to operate. And an important consideration in that was that it would result in diversification of Santee Cooper's fuel supply. It would be replaced by natural gas fired units, which would reduce the carbon footprint for Santee Cooper, and it would result in a more diversified fuel supply, which is better. It's less risky. So all of those factors weighed on the decision to put forth a portfolio that assumed retirement of Winyah.
Is there a state or federal requirement that Santee Cooper reduce their carbon footprint?
Not a specific requirement to that effect.
So in this 2019 study, you're saying that all generation sources, coal generation sources, were looked at in depth, and a benefit cost analysis was done. All the things were done to determine that we need to get rid of the Winyah plant early and add solar and other stuff. Is that what I'm hearing you say?
That was the output of the study, yes, sir.
That was the output of the study. And that was, again, kind of remind me, how was that study done to make these determinations?
The goal was to identify the lowest risk-adjusted cost portfolio for Santee Cooper, the combined system. assumptions were made about the cost of new generation, solar, the cost of purchasing solar under 20-year PPAs, et cetera, and the cost that would be avoided by retiring either Winya or Cross. Through a series of runs, computer models, it was determined that a portfolio that would add solar, add natural gas combined cycle, and retire Winya would be attractive for Santee Cooper's customers. It would result in a lower cost portfolio. It would have less risk. It would have lower carbon emissions, all very positive things, if you will, or changes, if you will. So that was put forward as the result or conclusion from that study.
And did that study consider and look at like supply chain issues, any issues relative to that as far as that could affect cost, reliability, security?
At the time, it was 2019, COVID hadn't happened and certain other things that affected us later hadn't happened. It was assumed that solar power projects could be built reasonably as planned, and so could natural gas projects.
So it was the assumptions that went into the model to make the outcomes that Santee Cooper is proposing to use, correct?
And that's correct.
Relative to the aggregated levelized cost of selected projects for the CPR portfolio, to confirm costs are comparable to the assumed cost data used in the approved IRP. Ms. Campbell, I believe, responded that this could be done, not that this is done. Was this done in the 2019 study and relative to the 2020 RFP?
Yes, it was. It was done in two steps, if you will. First, when the results of the RFI were received, the respondents provided indicative pricing. And that indicative pricing was very close to the assumption used for the cost of solar PPAs that was used in the studies that I've been referring to. And then 6 months later, the 2020 RFP was conducted, and the results of the 2020 RFP were even closer and actually right on top of the assumption as to the cost of solar used in those studies.
So you're saying, what I'm hearing you say is it was looked at in the 2019 study, and it was again evaluated after the proposals were received. Is that correct?
Yes, sir.
And you anticipate that's what would be done going forward also, wouldn't you agree?
Yes, sir. I think the decisions are an ongoing process. You make assumptions about the cost of resources, perform analyses and solve for a good plan. And then you start procuring those resources or further planning those resources. And either the costs that you used in the planning are confirmed or they're challenged. And if they're challenged, you consider whether the differences are large enough to change your decision. And you factor the latest information into the next planning study. I think it's important to remember that Santee Cooper's IRP not only will be done every 3 years, but updated annually.
Did, just out of curiosity, did the, I guess those costs come back higher or lower than estimated? Or
in the RFI, they were slightly higher, like a few percentage points. I don't remember exactly. With the RFP results, they were essentially the same as the assumption that had been made.
essentially the same? Does that mean zero?
I think that I did, so close as to be within the pencil width. The way I remember it, subject to check, the results of the RFP were just slightly under what had been assumed. Hence, or excuse me, a few cents or 10 cents or 15 cents lower than per megawatt hour than had been assumed in the planning studies.
Okay, thank you.
It was very close.
Understood, thank you. And the 5 projects, again, I can't remember if that was listed in your testimony or if in the application. The 5 projects that were selected from the 2020 IRP, I think they were, said 2 100 megawatt and 3 75 megawatt. Have those projects received all their permits and begun or completed construction or began construction? Do you know?
I'm not completely up on the status of those projects. The 2 100 megawatt projects are pressing forward toward completion. There's discussions ongoing with 2 of the other 3 projects to determine whether they're going to press forward or not.
Okay. Thank you, Mr. Painter. I appreciate it, and I think that's all the questions I have. Thank you.
Commissioners, further questions for this witness? Hearing none. Mr. Cooper, any redirect?
No, Chair Belser, no redirect.
Thank you. Mr. Painter, thank you for your testimony today. You may stand down.
Thank you very much.
Chair Belser, I just have one question. There was a question of mechanics that was brought up about discovery, whether it was answered and served. And if it would benefit the commission, I'm happy to explain that process. But if the commission had its questions answered, I don't need to.
I think if you want to go
Sure,
ahead,
I'd
Mr.
like to.
Cooper, that would be good. Thank you.
Just for clarification, going back in the record, there was some clarification of whether this was an independent third-party expert or consultant or commission consultant to understand the role. That was clarified. The directive provided instructions on how to serve discovery. We reached out to the consultant just further.
The commission's consultant.
Yes.
Let's clarify that.
We reached out and let them know that we would be happy to answer any discovery they might have, that they could issue it informally or however they'd like to issue it. And we were provided with discovery. We've answered all of that discovery directly, and that's been acknowledged. And that's in the normal course of how we would exchange and answer discovery for any other proceeding.
And let's be clear that the responses, because this is a commission consultant, independent consultant for the commission, the responses are not posted to the DMS.
That's correct.
Okay.
Thank you.
Thank you. Anything further from Santee Cooper at this point? Mr. Cooper?
No, that concludes our case.
Thank you. Central Nucor head witnesses, Office of Regulatory Staff, are we ready?
Yes, Madam Chair.
Okay.
ORS would call James Finley Salter to the stand.
And Mr. Salt, oh, he's here. Okay. Thank you. Mr. Salter, the court reporter needs to administer the oath, please.
Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good afternoon, Mr. Salter.
Good afternoon.
Would you please state your full name for the record?
James Findley Salter.
Mr. Salter, by whom are you employed and in what capacity?
I'm employed by the South Carolina Office of Regulatory Staff as a program manager in the Utility Rates and Services Division.
And did you prepare or cause to be prepared 10 pages of direct testimony that was pre-filed in this proceeding on March 31st, 2023?
Yes, I did.
And do you have any revisions or additions to your direct testimony filed on March 31st?
No, I do not.
If I asked you the same questions today as those posed in your pre-filed direct testimony, would your answers be the same?
Yes, they would.
Thank you. Madam Chair, at this time, I would ask that the pre-filed direct testimony of James Finley Salter be entered into the record of this case as if given orally from the stand.
Mr. Salter's pre-filed direct testimony will be entered into the record as if given orally from the stand.
Thank you, Madam Chair. Mr. Salter, by what criteria did you evaluate Santee Cooper's proposed CPRE program?
I evaluated Santee Cooper's proposed competitive procurement of renewable energy, or CPRE program, to determine if it met the requirements set forth in the statutory provisions of South Carolina Code 5831-227 as promulgated by Act 90. These requirements generally include the filing for commission approval, a program for the competitive procurement of energy, capacity, and environmental attributes from renewable energy facilities to meet the needs for new generation resources identified in the Santee Cooper's IRP or other planning processes. What resources constitute renewable energy, the timing relative to each solicitation for public availability of a pro forma contract, bid evaluation methodology, and interconnection requirements and study methodology. And finally, issuance of a public report containing specified solicitation results within a time frame and summarizing the results of each competitive solicitation.
Thank you, Mr. Salter. And was this review substantially similar to the review ORS performed for other utilities that have filed for proposed CPRE programs before this commission?
Yes, it was, save for the requirements that are specific to Santee Cooper as laid out in Act 90. My review was consistent with ORS's review of other programs.
And based on your review, Mr. Salter, does Santee Cooper's proposed CPRE program adhere to the requirements as set forth in Act 90?
Yes, it does.
Mr. Salter, are you aware that ORS is a signatory to a stipulation that was filed with the Commission in this proceeding on June 7th?
Yes, I am.
And Mr. Salter, is this stipulation is filed in the public interest?
Yes, I believe the stipulation that was filed is in the public interest.
And could you, for the benefit of the commissioners, explain why?
It is in the public interest because the application that Santee Cooper put forward does meet all the requirements as laid out in statute, and the stipulation resolves all issues amongst parties in the docket.
Thank you, Mr. Salter. Madam Chair, at this time, Mr. Salter is available for questions from the commissioners.
Thank you, Ms. Given. Commissioners, questions for this witness? Commissioner Carolee Williams. Oh, we'll come to you next, Mr. Commissioner Irvin.
Thank you, Chair Belser. Welcome, Mr. Salter. Do you believe that Infront's ability to be an independent consultant, that they can be an independent consultant in the way that ORS requested, or did ORS change their perspective on what was legally required?
Well, my recommendation in my testimony was to involve an independent third-party consultant, and I do believe that independent Infront could serve that role adequately.
And in your experience, is it best for the utility to have more say and control over the procurement process, or for another entity to manage and guide it?
Commissioner, I think that would depend on the specifics of each RFP and the conditions that the utility is facing at the time. There are pros and cons to both, but consistently, ORS believes that involving an independent third party adds value to the process and increases transparency.
And somebody will just have to stop me if you can't answer this. Did you determine that that Santee Cooper was receptive to this independent third party in deciding to be a signatory to the stipulation?
I did not formally verify that Santee Cooper accepted that recommendation. Their program that they put forward meets the requirements of the statute as is. So the recommendations that we put forward are recommendations, and I would hope Santee Cooper would take them under consideration. However, the program that they put forward meets the statute.
Thank you. No further questions.
Thank you. Commissioner Irvin?
Thank you, Madam Chair. Sir, I believe you testified that you believe that Santee Cooper's request complies with the statutory provision that's applicable in this docket. Is that correct?
That's correct, Commissioner.
And going forward, is it ORS plan to continue to monitor this particular RFP process to determine it is administered in accordance with South Carolina law?
Yes, sir. We'll continue to oversee all aspects of Santee Cooper's operation, including this, and we'll review the public report that is put out after each individual RFP. And so you'll be a separate set of eyes and ears that will be monitoring the process until its conclusion. Is that correct? That's correct. If anything came to your attention that seemed out of the ordinary or not in compliance with the stipulated settlement agreement, would you bring that to the attention of the commission? We could, but I just wanted to reiterate a point that I make in my testimony that the ORS is not an appropriate organization to perform any type of independent third party as far as administering the RFP. I understand. My question was not a good one. Let me rephrase the question. Does ORS and staff stand ready to assist the commission that to determine that Santee Cooper's proposal continues to meet the statutory requirements of the Act? That's correct. And should anything occur that concerns ORS, you have a duty to call it to the commission's attention, do you not? Yes, sir. For example, if they varied from the statutory requirements of this program for renewable energy procurement, if they went outside the purview of the statutory provisions or took some action that you thought was not in the public interest, you would recommend that ORS intervene and let the commission know. Is that right? If Santee Cooper stepped outside of the statutory requirements or approved program, ORS would pursue action. And just thinking about your question, one opportunity is when the independent report is published by Santee Cooper. If ORS disagrees with anything in the report, we may let our disagreement know at that point in time. Okay, and you're aware that the commission also retained the expertise of an outside independent third party
analyst. What is ORS's position on that matter? Do you think that we need to hear from our independent expert prior to approval? Would that be your preference?
With respect, Commissioner, I don't have a preference on the commission. You're talking about the commission's third-party expert?
Yes, sir.
Yeah, I don't have a preference on the commission's third-party expert.
Well, do you think that commission will be in a position to approve the program prior to receiving the report?
Madam Chair, I'm sorry, I don't make
Just hold on, Commissioner. Ms. Given, is there an objection?
Madam Chair, I don't make it my practice to object to commissioner questions, but I think this is getting outside of the scope of Mr. Salter's review.
I'll
And to the
withdraw the question, no problem.
Thank you.
Mr. Salter, thank you, Mr. Salter, for your testimony. No further questions.
Thank you, sir.
Thank you, Commissioner. Commissioners? Commissioner Justin Williams?
Yes, ma'am. I think my light is on. I got a few questions for you, Mr. Salter. Maybe just one. There's been much discussion about the benefits of an all-source procurement program versus a competitive procurement program for renewable energy alone. Could you share your thoughts on the differences between the two and the benefits of each?
Yes, I would like to, Commissioner. All-source procurement and competitive procurement of renewable energy. First of all, my review in this case was specific to this competitive procurement of renewable energy program that was put forth by Santee Cooper and that it met the requirements of the statute. I've listened to the discussion today regarding all-source procurement, and ORS has consistently recommended the use of all-source procurements in past proceedings. Generally, where all-source procurements retain the most value is when the utility is procuring needed capacity as opposed to an energy resource. So as far as a CPRE program, my recommendation here in my direct testimony was to really draw that distinction between the need for an energy resource as opposed to the need for a capacity resource.
Thank you. No further questions, Madam Chair.
Commissioner Caston?
Thank you, Madam Chair. And good afternoon, Mr. Salter.
Good afternoon. I think I forgot to put my placard out, so apologize for that.
Well, I knew it up until I was about to ask you a question. And then it went, wow. That happens a lot lately.
It's getting past lunch, isn't it?
Relative to this use of third-party consultant, is there any third-party requirement in Act 90 relative to Santee Cooper?
No, sir, there's not.
But ORS still believes that a third party.
Yes, sir. ORS consistently prefers an independent third party to assist in the administration of whether it's a competitive procurement of renewable energy or an all-source procurement, as it adds transparency to the process.
And I believe in Ms. Williams' testimony, I don't know if we touched on it this morning, but she stated in her testimony something to the effect that, third party consultant, Ms. Campbell, I'm sorry. I'm glad they're both on side of me. Ms. Campbell, I think, stated something along the lines that, third party can mean different things to different groups or different people. Would you agree with that?
Yes, sir.
So if a third party is used, there's no one right way or one size fits all. Is that a fair statement, or is that not?
That's correct. I think it would depend on the conditions that were in place at the time of the specific RFP.
And the primary purpose, again, I know it's been talked about a lot, but there may be multiple answers because there's multiple views of what that is, but what's the number one reason that you believe or ORS believes that it's wise or good practice to use a third party, whatever we call it?
Yes, Commissioner. I mean, the number one reason I would say is it brings another level of transparency to the process and another level of integrity to the process when you're bringing an outside expert in to assist in either evaluating or administering your program.
Okay. I think the way Ms. Campbell had described it previously was they used a consultant, a third-party consultant, I guess, to help them pull stuff together, help them think through, and I'm paraphrasing, but not make the decision for them. Do you agree with that?
Commissioner, I was not directly involved in the 2020 RFP that Witness Campbell was describing. I did read in Witness Painter's testimony his description of Infront's role as a third party during the 2020 RFP, and he did describe Infront's role as an independent administrator, among other details that were provided, and I believe that they added value to the process as it was described in the testimony.
Okay. I believe that's it. Mr. Salter.
Thank you.
Thank you.
Commissioners, any further questions? Good afternoon, Mr. Salter. I hate to harp on this, but in your testimony, I think, as you just stated, you indicated that Mr. Painter had said that they used an independent third party to administer procurement of renewable energy. Is that correct? Independent third party to administer. And where I'm going with that is, does that equate or equal an independent administrator?
I know that some of the terms get crossed. Based
I have that problem.
Right, but based on, that is what was stated in the testimony. Based on the description, I would not equate their role to an independent administrator.
And you're exactly where I am right now. But with the stipulation ORS has signed onto, ORS is in agreement with the guidelines that Santee Cooper has put forth. Is that correct?
Yes, ma'am, that's correct.
Okay, thank you very much. Commissioners, anything further? Ms. Given, any redirect?
No redirect, Madam Chair.
Thank you. Mr. Salter, you may stand down. Thank you for your testimony today.
Thank you very much.
Is there anything further from ORS?
Nothing further from ORS, Madam Chair.
Anything from any of the parties? Mr. Cooper?
Nothing further. Thank you, Chair.
I thought you were just itching to say something there.
Just a final thank you, but that's it. Thank you.
Okay. We do have our commission consultant that is going to issue a report, which I don't recall the date that the report will come out. And at that time, certainly, y'all will have it to review and prepare for that. And We're going to close today's proceeding, but I do caution everybody, we have Tuesday, September 12th at 10 a.m. reserved for the Commission's independent consultant to come and answer questions about whatever his report says. So we will adjourn until that time. So,
Madam Chair,
Commissioner Urban?
thank you. Just a housekeeping matter. I'm wondering, I know that we mark for identification certain items, including the stipulated agreement. Has that been entered into the record yet?
Yes, sir. We have two hearing exhibits. Hearing exhibit number 1 is a stipulation. It has been admitted into evidence. And number 2 is Mr. Painter's CV, which has been admitted into evidence. And then parties correct me if I'm missing anything.
Thank you.
Thank you, Commissioner. And with that, we are adjourned today, and we'll see y'all on September 12th. Thank you very much.
Thank you.